all this figure and to know that actually Brazil is a really heavy user of arbitration. It will be good if there will be more arbitration used around and be centered around in the Portuguese-speaking country. Now, with this note, I would like to introduce the first speaker, Professor António Pinto Monteiro. Professor Antonio holds a PhD degree in procedural law and a post-graduation from the Nova School of Law. He is an associate professor as well as a lawyer and an independent arbitrator. Antonio has written several books and scientific articles, and he is currently the editor of APA's Review of Arbitration. He has been distinguished by several entities. Leaders Election 2021, Portugal Best Arbitrators, Who's Who Legal Arbitration 2021 and 2022 Future Leader, and Legal 500 Private Practice Arbitration Power List 2023. Professor Antonio will read on the new end of the maritime civil law, go back to the home country, Portugal, and speaking about the topic of maritime arbitration in Portugal. Without further ado, may I hand over the floor to Antonio, please.
Thank you very much. First of all, I would like to express my gratitude for the invitation to be here today. It's a pleasure and an honor to participate in this webinar together with you, Mr. David Fong, as well as Mr. José Gabriel Cid Almeida and Ms. Cátia Fernandes. So, considering the title of this webinar, which is Maritime Arbitration in Portuguese-speaking countries and in the Maritime Silk Road, the premise of my presentation will be to assess whether Portugal, particularly Lisbon, can one day aspire to be an important center of maritime arbitration, similar to the ones that we can find in London, in New York, as well as in Singapore and China. Well, this is something that makes sense, considering the pro-arbitration stance that we can clearly find in Portugal, particularly in the last 20 years. Just to mention a few examples of this, I mean, we have many disputes being submitted to arbitration, we have many scholarly writings, we have many conferences, courses, post-graduation degrees on arbitration. We have many arbitration centers, and most importantly, good arbitration centers in several matters such as commercial arbitration, sports arbitration, administrative and tax arbitration, consumer arbitration, and soon, I hope, maritime arbitration, a center created by Concórdia. Another example of the pro-arbitration attitude in Portugal is, of course, the Portuguese arbitration law, which I will mention in a few moments, and which was inspired in the UNCITRAL model law. We also have a very active arbitral community and an association, the Portuguese Arbitration Association, APA, which has contributed significantly for the arbitration growth and development in Portugal. So, like I said, given this pro-arbitration stance, the question arises, can Portugal one day become an important center of maritime arbitration? In order to assess this, I will divide my presentation in three parts. And now I will open the PowerPoint presentation that I have prepared for this webinar. I believe all can see the PowerPoint presentation. So like I was saying, I will divide my presentation in three parts. First, overview of arbitration in Portugal. Secondly, I will address the relationship between state courts and arbitral tribunals. And finally, I will analyze the possibility of Portugal become a strategic seat for maritime and international arbitrations. The focus of my presentation will be arbitration per se and not maritime law. So I already covered the introduction, so I will pass these slides and I will go straight to the first part of my presentation. Overview of arbitration in Portugal. I will provide a brief overview. And first, just a short historical reference. There is no doubt that in recent years, perhaps in the beginning of this century, arbitration has acquired a growing importance in dispute resolution. It has captured the attention of many different people. But the truth is, as we all know, arbitration is very, very old, and Portugal is no exception. Arbitration in Portugal has a long tradition. For instance, in what specifically concerns legislation, and I'm just referring to legislation, In Portugal, arbitration was already foreseen and regulated in the 15th century in the so-called Ordenações Afonsinas of 1446-1447. Afterwards, it continued, of course, to be included in several laws. There was always a legal framework. So it has a long tradition, but what is the current legal framework in Portugal concerning arbitration? Most importantly, is it pro or anti-arbitration? Well, these are important questions that we must ask ourselves. And when addressing the legal framework in Portugal concerning arbitration, it is particularly important to mention, first, the Portuguese Constitution. The Constitution expressly provides in Article 209, paragraph 2, that arbitral tribunals are considered jurisdictional bodies. Therefore, arbitration in Portugal enjoys a constitutional status. According to the Constitution, arbitral tribunals are a jurisdictional means for resolving disputes, period. I mean, there is no doubt about this whatsoever. Secondly, it is a fundamental important to mention the law on voluntary arbitration, Law 63, 2011. This is the main arbitration law in Portugal. It's not the only one. We have a specific law for tax law arbitration, for sports law arbitration, for administrative arbitration, but this one is the main law, the Portuguese law on voluntary arbitration. So I will now mention some of the relevant features of our current law on voluntary arbitration that might be relevant to consolidate Portugal as an important center of maritime arbitration. There is no time, of course, to address all of its features, so I will focus on the main ones. First, arbitrability. According to Article 1 of the law, any dispute involving economic interests may be referred by the parties to arbitration. Furthermore, according to paragraph 2, an arbitration agreement concerning disputes that do not involve economic interest is also valid, provided that the parties are entitled to conclude a settlement on the right in dispute. I believe it's similar than the Brazilian law. This means that in what specifically concerns arbitrability of disputes, Portugal has adopted a liberal and wide criteria. Second feature, relevance of party autonomy. This relevance can be seen on various levels in our arbitration law. For instance, in what concerns the choice of the arbitrators, similar to the Brazilian law, there is no specific restriction on the choice of an arbitrator. The Portuguese arbitration law only has a specific provision concerning the requirements an arbitrator needs to meet. Under Article 9, these are essentially two. The arbitrators must be individuals and enjoy full legal capacity, and of course, the arbitrators must be independent and impartial. Besides that, the parties are, of course, free to choose the arbitrator they want. Also, the relevance of party autonomy can also be seen, for instance, regarding the parties' freedom to choose the applicable procedural law rules, according to Article 30. Thirdly, another relevant feature in the arbitration law, in my opinion, is the relevance given to independence and impartiality of the arbitrators. Differently from the previous law, the current Portuguese arbitration law expressly establishes that arbitrators must be independent and impartial. And of course, it goes beyond that. The arbitration law also establishes the arbitrator's duty of disclosure, similar to the UNCITRAL model law, and the law also adopts a standard of continuing disclosure. In my opinion, the relevance given to independence and impartiality in the law contributes to the integrity and credibility of arbitration in Portugal, hence its importance. Fourth, interim measures and preliminary orders. Contrary to the previous law, the current Portuguese arbitration law closely follows UNCITRAL model law and as such admits the possibility of arbitral tribunals to order interim measures and preliminary orders. It also provides that despite the existence of the arbitration agreement, it is possible to request an interim measure in a state court. This will not be a breach of the arbitration agreement. Fifth feature, complex arbitrations. I'm referring, of course, to multi-party arbitration when we have more than two parties, more than one defendant and or more than one claimant. This is quite common nowadays. The globalization and fast growth of international trade in recent decades have led to an increase in the number and complexity of commercial transactions that often involve more than two parties. Well, traditionally, this complex arbitrations issue is not usually dealt by arbitrations law. Take the UNCITRAL model law, for instance. Nevertheless, the current Portuguese arbitration law has two articles on this subject, Article 11, regarding the constitution of arbitral tribunal when there are multiple parties, which was inspired by the ICC rules, and Article 36 regarding third-party joinder. Last but not least, I would like to highlight three relevant and different features of the Portuguese arbitration law. The impossibility to appeal as a rule. This is foreseen in Article Article 53 and also Article 39, paragraph 4. The limitation on the grounds to set aside an arbitral award, according to our Article 46. And it's also worth mentioning the wide enforceability of awards. According to Article 42, paragraph 7, an arbitral award rendered in Portugal is enforceable in the same terms as a judgment rendered by a state court. So there is no need for an exequatur decision from a state court. It is also important to emphasize that Portugal is a party to several international conventions regarding arbitration, such as the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, as well as some bilateral treaties entered into between Portugal and other Portuguese-speaking countries. So in short, we can say about the Portuguese law on voluntary arbitration that this law is clearly the result of a friendlier environment in Portugal towards arbitration that can be seen at various levels, political, case law, practical, academic, etc. And the law also confirms that Portugal is an UNCITRAL country, since our law was clearly inspired by the UNCITRAL model law. Second, that being said, I will now address the relationship between state courts and arbitral tribunals. I mean, the good relationship between state courts and arbitral tribunals that we can find in Portugal. This is the second part of my intervention, and I will be brief. It is usually said that state courts can exist without arbitration, but arbitration cannot exist without state courts. This is from Redfern and Enter on International Arbitration, one of my favorite international arbitration handbooks. And this is usually said because there is a relationship between state courts and arbitral tribunals, a relationship that is said to be one of partnership, although not a partnership of equals. The relationship between state courts and arbitral tribunals, in my opinion, is important to the effectiveness of arbitration as a means of dispute resolution. So state courts have an important role in arbitration, and this can be seen particularly in two levels. There is a support function. State courts sometimes assist arbitral tribunals, and there is also a control function when there's an application for setting aside the arbitral award. Regarding the support function, Portuguese law has several provisions on this. For example, in what concerns appointment of arbitrators, taking of evidence, interim measures, the possibility to decide on the challenges of arbitrators or their removal, and so on. And considering this support function, and from my experience, I think we can safely say that Portuguese courts are usually supportive of arbitration. There is also an arbitration-friendly case law that has emerged over the years. So to sum up, the relationship between state courts and arbitral tribunals in the Portuguese jurisdiction so far, it has been a relationship of partnership, in my opinion. Finally, I will analyze the possibility of Portugal become strategic seat for maritime and international arbitrations. This is the last part of my intervention and comes as a conclusion regarding what I have previously mentioned. It is usually considered that Portugal is well placed to receive international arbitrations, particularly considering the pro-arbitration legal framework, as well as the good relationship between state courts and arbitral tribunals that I've mentioned before. But there are also other relevant features. We have a very active arbitral community. Portuguese legal practitioners are usually able to speak English, Spanish, and other languages. Portugal has very strong contacts with Africa and South America, particularly with Portuguese-speaking countries, and it's also peaceful, enjoyable, secure, and open to foreigners. Regarding maritime affairs, recently, there was an interesting development that, in my opinion, could become an important step forward in promoting maritime arbitration in Portugal. I'm referring to the creation of CAM, Centro de Arbitragem Marítima de Lisboa, Arbitration Maritime Center of Lisbon, a center that was created by the Concórdia Association. Just by way of introduction, Concórdia Association is a non-profit association that was established by lawyers and other legal experts with experience in arbitration. In 2013, Concórdia created an arbitration center, the Concórdia Center, to manage arbitrations concerning domestic and international disputes of any kind, including civil, commercial, and administrative disputes. Recently, Concórdia also launched a project for the creation of a new arbitration center, this time an arbitration center specialized in disputes concerning maritime and ocean law, the CAM, the Centro de Arbitragem Marítima de Lisboa. This is something positive. In Portugal, maritime trade businesses and legal community felt the need to create an arbitration center specialized in maritime affairs, in maritime industry disputes. This need is quite clear given the growing importance of the maritime industry to the national economy. As Cátia Fernandes mentioned before, Portugal is a maritime country. We have an historical tradition as a maritime nation. Concórdia was aware of this need and fortunately was able to create this center. Well, technically, as far as I know, it's still awaiting the required authorization to start functioning, but probably this is just a matter of time. Nevertheless, the list of maritime arbitrators and experts is already available online in the Concórdia website. So based in the Concórdia Center, CAM will provide a center specifically directed to players in the maritime sector and probably will attract players from the Portuguese-speaking countries. To conclude, I would say that this looks promising for the future of maritime arbitration in Portugal. Time will tell, but I would say that this was indeed an important first step to make Portugal a strategic seat for maritime arbitration. This is all. Thank you very much.
Thank you so much, Antonio, for your presentation. Now, after listening to your presentation, I would definitely answer your questions posed on the first page of your slide as a definitely yes. With this note, actually, I'm very happy to introduce our new panelists, as the last slide of Antonio mentioned is about Concórdia. We are very happy to have Mr. Antonio Cardoso, Chairman of Concórdia, to give us an introduction regarding the Maritime Arbitration Center they are establishing. So can I invite Antonio to speak to us on this particular matter?
Thank you very much. I think I don't have you don't have my age, but you can manage to have my voice. Well, thank you very much for all the panelists for this very interesting and valuable conference that I think that can make some links between all these parts of the world in the matter of maritime issues. Now, about Concórdia. Concórdia is an association, as Mr. António Pinto said before, Mr. Pinto Monteiro said before. It is an association that has been created in 2003, and now 20 years old, and has been created as a mediation center. That was the initial idea of this association. And then 10 years after, it had shift to arbitration and managed to create a general arbitration center that has been in place ever since. Now, in 2002, there was a movement in our associates in order to create a maritime center of arbitration. The idea was to overcome a problem that the legal community had in maritime disputes, because the maritime court, there is only a maritime court in Portugal, was overloaded of cases and could not answer the litigators in a expeditious manner. So we move forward to create the center, and we have managed to assemble a very valuable number of lawyers dedicated to maritime law. There were mainly academics, professors of universities, and also attorneys of law acting in the maritime courts. There were also some experts in several technical matters that joined also this project. So with that, we managed also to assemble some associations of maritime entrepreneurs, like agents and also other people linked to the shipping activity. So now we have a group of associates that are either associations of enterprises and also professionals of maritime law, and also experts that can this group can give us confidence that we can go ahead with this center in an effective way. Finally, as Mr. António Pedro Monteiro said, we have applied for an authorization to go ahead. This authorization is supposed to be given by the government through the Ministry of Justice. We have learned that this authorization is coming soon, hopefully, and so we expect to be working in the second half of this year. We expect this to be a success, and of course, we are sure that all these stakeholders will have confidence on this center and will adhere to it enthusiastically, as the other have done so far. So this is what really is going on at this moment.
Thank you so much, Antonio, for speaking as the chairman of Concórdia, the co-organizer. We will definitely know more about your center after your speech. And we are very happy that today your center is in as a co-organizer. And with this note, we will turn to the next section of the webinar. I looked the clock close to 8 p.m. Macau time, but still I would like to have a short session of for 5 chat with all the speakers together. I would like to kick off the process first. After listening to all the presentation, and also I would like to give a reflection as a Hong Kong practitioner. As all of you would know, Hong Kong went the first most preferred seat of arbitration by the Queen Mary University London and Y&K survey in 2021. But what factor being factored into this kind of ranking, and whether the Portuguese-speaking country or region can learn from this experience and establish themselves either as the maritime arbitration center or arbitration center for the Portuguese-speaking country. I would like to adopt a model proposed by Professor Anselmo Reyes in the book of the Developing World of Arbitration published in 2018. Basically, how he looked into a arbitration-friendly jurisdiction or co-arbitration jurisdiction with these features. It's a modular jurisdiction. It has an established arbitration center. It has the competence in terms of people's capacity, of course, lawyer, arbitrator, but also all the supporting workers in this industry. And also, there must be a really co-arbitration court with the judicial support. Now, with this factor in mind, I would like to reflect myself and look back to Hong Kong. Hong Kong is a model law country. Well, of course, we have an established arbitration center, Hong Kong International Arbitration Center. Our judiciary is well known in the common law world that support arbitration. And in Hong Kong, we have a large pool of lawyers, arbitrators, experts, and also all the supporting staff for arbitration, like, for example, interpreters, and even including arbitration venue rental, such as hotel or a business center. Now, if I look into this factor, what I can share with all the speakers, and all the speakers can give some reflection, whether any Portuguese speaking country or region that would fulfill this particular criteria as a starting point of discussion. I heard that, I understand Macau is a model law jurisdiction. I also learned from the previous presentation that Brazil and also Portugal is also model law jurisdiction. But besides this, I would put one more additional factor that I would like to discuss with all of you is, as all of you know, London is the top international maritime arbitration center in the world. In Asia, we have Singapore and also Hong Kong. All these are common law jurisdictions, but what they share in common is not only the legal system. For any common law jurisdiction, there's one thing in common, is English as a speaking language. All common law jurisdictions speak language, English. So with this note, I also refer back to the Portuguese speaking countries. You have the similar legal system, you speak with the similar heritage, and also all of you, of course, speak Portuguese. So with all this note and factor into mind, I would like to have a discussion with all the speakers. How would you view different Portuguese speaking countries, as I mentioned at the beginning, from South America to Asia to Europe and down to Africa? There must be an arbitration center that can lead the races and also establish itself as a maritime arbitration center. In particular, given Portugal, actually, if my history knowledge is correct, is the first, actually can be regarded as the first maritime nation in the medieval Europe. So I would like to kick off the discussion with all the speakers, whether you have any thoughts that which part of the, or which country or region of the Portuguese speaking country can put themselves, or it can be more than one maritime arbitration center. Of course, Portugal has an advantage is being a maritime country per se. I just, before I hand over this discussion with the speaker, I also want to highlight one particular fact, is that it's the language issue. Common law jurisdiction have the common in English. Of course, all your country has the common in Portuguese, but I understand Portuguese is also very close to Spanish. And as the speaker mentioned, majority of the lawyers in the Portuguese speaking country is also competent in English. And probably those colleagues in Macau are also competent in Chinese. These are really big disadvantage. Actually, even over Hong Kong, Hong Kong, I as a practitioner, I only know Chinese and English. So with all this note, I would like to kick off the discussion process with all the speakers. How you will this factor can consider and also is how to establish a maritime arbitration center in the Portuguese speaking particular jurisdiction or country in mind that can take the lead. Well, with this note, maybe I invite the Catila to speak first about have some sharing.
Thank you very much, David. Very interesting, your question. And I was thinking about a lot of things, actually, because, you know, I think that if you look into Portuguese-speaking countries, I really think that you need to find between them the one that has the capacity to really become a hub or a cluster in terms of shipping. It makes sense for that. And as I was telling in the very beginning, I think that Portugal is starting to create and to build, or at least is doing the right steps in order to create a cluster in Madeira. Of course, that when you think about a cluster, you think about a business center or a combination of interconnected services. And I would say that at this moment, Portugal does not offer all of that. We are doing steps, but when you think about a hub, you think about, for instance, in terms of having a strong financial center also. So in terms of ship finance, for instance, Portugal is still, it has no tradition in terms of ship finance, for instance. Also, we need that for sure. Portugal would need to stimulate specific sectors of the shipping industry, and I am talking about shipbuilding, for instance, that needs to be developed in order to have a real, a real cluster, a real hub. But in fact, when you look into the other Portuguese-speaking countries like Cape Verde, or if you look into Moçambique or into Angola, I would think that Portugal is indeed in a better position in terms of having or presenting, in terms of the Portuguese-speaking countries, presenting itself as an alternative, as a good alternative for arbitration. I would also like to hear José Gabriel. I am not so familiar with the Brazil shipping industry, and would be nice to hear his thoughts. But I would say that Portugal offers the conditions. There is still more to do, and also CAM, the arbitration center, the Maritime Arbitration Center, is definitely one very good contribution. So I think that Portugal is indeed in an advantage situation when compared to other Portuguese-speaking countries.
Thank you so much for your sharing. Well then, Catila just mentioned about Brazil, so it's naturally for me to ask Jose, what is your view on this subject matter?
Thank you very much, David. This is, as Cátia said, this is a very good question. I think that there are three requirements for having an arbitration hub. First is quality of the arbitration. Second is cost. And third is the absence of regulatory issues. When you look at, for example, London, and you see that there is quality, but there is also high costs. So it is, you have to have the three criteria to become a maritime arbitration hub. I would allow myself to go a little bit further than your question and say maybe we should not choose a country, but maybe we should choose an offshore platform, because in a certain way, international arbitration can be detached from national orders and national legal systems. And I think that there is nothing as much international as maritime transportation. You know, when you're talking about international maritime transportation, I think it is the most international thing or activity that you can have. And so I concur with Cátia Fernandes. I think that Portugal has the stability, Portugal has the cost, Portugal has the quality of arbitration, and Portugal has no regulatory issues, as Professor António Pedro Pinto Monteiro showed us, has no regulatory issues or legal issues or a legal framework that is against arbitration. But maybe we could go a step further and think about an offshore center for international arbitration. We could move forwards, and as the Portuguese maritime mates in the 16th century and the 15th and 16th century that discovered the world, maybe we can allow ourselves to go a little bit further and move to something like that. Thank you very much.
Thank you so much, Jose. How about Antonio? We would like to listen to your view.
Thank you very much. It is, in fact, an interesting topic. Portuguese-speaking countries, they share the same language, but also the laws are similar. In some laws are quite similar. I think that Portugal geographically it has a position geographically because it's in the beginning of Europe between South America and Africa. But I believe I agree what José Gabriel Assis Almeida mentioned. Perhaps the creation of a center for international arbitration outside Portugal, Brazil, or other countries could be also an interesting idea, of course. Thank you.
Thank you so much, Antonio. Indeed, I do agree with this excellent idea to create an offshore platform as a maritime arbitration center. It does not need to be necessary to be located in any particular jurisdiction. And Cátia also point out one important aspect of this often missing part of this maritime arbitration regime is about the banking and finance industry that support the shipbuilding and the ship mortgage. Well, this must be the starting point for any shipping matter. If you want to have a vessel, there must be proper financing to build up the vessel before they can be seagoing. So this is quite an often missing part of any maritime arbitration center. But this is an area that all the Portuguese-speaking countries can maybe focus to develop and fine-tune the system in order to take one step further in developing a maritime arbitration center. And with this note, I would like to come to the Q&A section. There are a few questions on the Q&A box, and some of them may not be speaker specific. So we will be open for all the speakers to, if you are interested to share your comment. The first question is that I read out to all the audience. Is there any existing uniform regime for the resolution of shipping dispute other than the use of rules including in international treaty instruments such as the New York Convention? If the existing system is not adequate, which steps are underway in order to conceive, discuss, and draft an uniform regime, if any? What is the view of our distinguished experts from Brazil and Portugal? I would like to kick off to the answer of this question first. Insofar as I looked at, well, there's not really particular uniform regime really specific for the maritime sector or shipping dispute. All the regime now start right on the general regime for arbitration. You have the model law, you have the New York Convention as the basic framework. And of course, if you go down to the shipping dispute, then probably you have a number of maritime arbitration center or association that specifically cater to resolve maritime dispute. Like the most famous one is the LMAA, the London Maritime Arbitrators Association. In Hong Kong, we have the Hong Kong Maritime Arbitration Association, etc. But with this particular question, the audience also asked the view from the speaker from Brazil and Portugal. So can I invite any speaker to respond to these questions or have any comment? I
suggest that we start by Portugal now. Maybe Professor António Pedro Pinto Monteiro would start, and then I can add to it.
Well, regarding if there is a uniform regime for the resolution of shipping disputes, well, as far as I know, I mean, like I was saying before, the laws between there are some similarities considering the laws of Portuguese-speaking countries, particularly regarding arbitration. Many arbitration laws today are inspired by the UNCITRAL model law, so there is a certain harmonization on that. But specifically concerning shipping disputes, well, I'm not sure if there is a uniform regime. As far as I know, I don't think there is.
There is not, indeed, there is not. And if we go actually for the good solution or alternative that José Gabriel presented of having this offshore arbitration center, for sure we will need to create a regulation from scratch, as far as I understand. So no, there is no common regulations at the moment, and it would be very interesting to create something that can be a broader regulation covering all Portuguese-speaking countries.
Thank you for the sharing by all the three speakers. Well, we go to the next question. This question is directed to Antonio. What would you say is the role model in which the Maritime Arbitration Center of Concórdia could follow? United Kingdom, Hong Kong, or Singapore, or probably other places?
Well, that's an excellent point. That's an excellent point. Well, I was not involved in the creation of this center, so the information that I have is limited. And well, the center is still awaiting the required authorization to start functioning. And I do not know what the rules of arbitration of this new center. I have not seen them yet. So I cannot, in reality, give a proper answer to this. But there are, of course, there are some specificities regarding these jurisdictions. Portugal is a civil law country, and we have to have in mind that, of course. But I'm not sure what the position of Concórdia is regarding this this subject. Like I said, I mean, the rules, as far as I know, are not yet published.
Thank you so much. Yes, please.
I may add something to that.
Yes.
Because really the regulation for arbitration in the center has been already drafted, is supposed to be approved by the government, but it's basically it comes from the Portuguese law on arbitration, voluntary arbitration, and the practice that we have in other centers of arbitration in Portugal. So the idea was to make something that is not far from what is the practice in Portugal, in order to allow the practitioners to be involved more easily. But of course, we have reviewed all these regimes that you mentioned, of those regimes of arbitration in London, Singapore, Hong Kong, and New York. And we believe that we have no rules that really are so different. I mean, they can be in some way not exactly the same, but the general idea, we accommodate basic principles in all these legislations, these centers and regulations. So this is what we have done so far. Maybe that in the future, because the practice will dictate how things will flow in the future. We wanted to become more close to our system and to the practice of our lawyers and see what we can do with that. And so afterwards, we are competing with the court in Portugal, not competing with Singapore Arbitration Center, rather London Arbitration Association, Maritime Arbitration Association, that is not really a center of arbitration. It is an association of arbitrators that make ad hoc arbitration. So we have to deal with all these circumstances, and mainly to address the specific problems that we have now in Portugal with maritime litigation. And then we can go to other avenues that may be open to this center. Thank you.
Thank you so much, Mr. Chairman, for your wonderful sharing. I have no doubt Concórdia is a good starting point to support the whole process. Well, and let's go to the next question. Actually, this question is for myself. Well, I read out the question. As Hong Kong is also one of the leading maritime arbitration centers with long-standing tradition. Sorry, my apologies. Yes, and let me continue. As Hong Kong is also one of the leading maritime arbitration centers with long-standing tradition, what are the key takeaways in what makes Hong Kong so relevant for the type of arbitration, and what can other jurisdictions learn from Hong Kong? Well, my real actually is evolving around the proposed model developed by Professor Anselmo Reyes in 2018. If you look back, while Hong Kong is as a top thesis in the world, it took a long time for Hong Kong to develop. This is the first thing. The Hong Kong International Arbitration Center was established in 1985, and it's almost 40 years ago. The model law, the 1986 model law, was enacted in Hong Kong in 1991. And it took a long time for Hong Kong to develop up to the current stage. So if you ask me whether there's one particular thing to share, you may not be expected, but it's rather the perseverance or the persistence by the legal and arbitration community at large to have a focus and evolving itself as the arbitration hub. Like insofar as the Maritime Arbitration Center is concerned, like Hong Kong is still a key shipping port in the world. The port, if I remember correctly, Hong Kong is still a top 10 container port in the world, and our shipping register by way of tonnage is the 4th in the world. So these are the factors that would support a holistic shipping industry in Hong Kong that will be Maritime Arbitration Center and be part and parcel of this holistic shipping industry. And the first thing I would like to mention is that this may be distinguished from other civil law jurisdictions. English law actually, so far, is the main international transactional law, and so does English as a language. So Hong Kong as a common law jurisdiction ride on this tradition. And insofar as the maritime arbitration case I dealt with, vast majority is governed by English law, if not Hong Kong law or Singapore law. And on majority of the occasion, the arbitration will be in London, because this is for historical reason. London being put in the standard contract shipping form. But however, now Hong Kong and Singapore is also being picked as the one of the arbitration center to be picked up by the parties, together with New York as the seat of arbitration. So we have this advantage that may be for other country or jurisdiction to consider to follow. I hope I can answer this question. Okay, we have a few more questions. Well, given the time, maybe I pick up one more question from another audience. This question is like this: most ships in the world are registered in tax haven. That is, they carry the flags of the country that are tax havens. For example, Panama. Even if this ship had never set the foot in those places, such executing a decision obtained in arbitration. It seems this is not a question, because it seems this is not the question is not yet finished. And I have one more question that actually I'm not sure, because it's in Portuguese. Can I shuffle Bruno to help out on the last question? And I'm not sure whether it's a question, because I cannot read at 8:21 p.m.
No, actually, it's not a question, David. I don't think it is. It's just someone saying thanks. I need to leave, but I would like to thank for the excellent
thank
presentations.
You so much. Okay. Thank you. Then I will go back and pick one more question from another audience. He asked, having in mind that a large number of the shipping arbitration are solved by arbitration centers located in common law jurisdictions. For example, London has 75 to 80% of the total, followed by New York and Singapore. Would it be viable to create a useful arbitration court using what could be a blueprint for the future worldwide uniform regime for the resolution of shipping disputes, and gradually contributing to the use of continental law concept, continental law arbitrators? Wow, very interesting questions. And it's quite inspiring what the audience asked. So I wonder any sharing from the speaker. Maybe we start with Professor Antonio first.
Thank you. I think we already, if I'm not mistaken, I think we already covered part of this topic regarding the idea to create an arbitration center between Portuguese-speaking countries, a Lusophone arbitration center. If I'm not mistaken, I think we already covered this idea, which is indeed very, very interesting.
Thank you, Professor Antonio. Any other sharings from other speakers?
Maybe just to add that I think that I am a little bit afraid of the idea of future worldwide uniform regime for the resolution of shipping disputes, I think that it's difficult to have a uniform regime, because you can have you can have a set of rules, procedural rules related to arbitration. I think that is possible and achievable. That you have that are common to a certain number of countries, and to an arbitration center that people are willing to adhere and to bring their disputes to be solved in this arbitration center. However, I think that it will be a little bit difficult to have a sort of worldwide rules. I think that law is very I think that the word in English is changeable and adaptable to the different situations. What we are discussing now is not what we would be discussing, what we discussed 10 years ago, or 20 years ago, or 30 years ago. So I think it's we have to take that with the somehow careful approach. On the other side, it is important that we struggle to have a little bit of civil law applied in international maritime arbitrations. But once again, it depends on an economic trends. The one who has the best economic cards is the one that dominates the game. That's life as it is. I think it's not. That's it.
Thank you, Hussein. Well, with this particular law, now the court come to 8:30 p.m. Macau time. I think it's probably a right time we conclude the session today. I'm sorry that there may be other questions asked by the audience, but due to insufficient time, we cannot cover every single question. But with this particular law, I would like to invite Bruno, the president of ALAM, the organizer of this webinar, to speak a few words in concluding this webinar. Thank you, Bruno.
Thank you, David. First of all, thank you for the excellent moderation. Thank you to our excellent panelists. It was extremely informative. And a special thanks to Concórdia for the challenge that you raised to us in having this webinar. And I'm sure that the center that is being created will be a huge and important milestone in maritime arbitration, in particular to the Portuguese-speaking countries, but also in connection to the Maritime Silk Road. I think that's, from our point of view, that are based in Macau and China, we realize this could be very important for you to take into consideration. Also, thank you very much for the participants. The mission of ALAM is to act as an aggregator of knowledge about arbitration in the Portuguese-speaking countries, and today, with your help, that was possible. I would like to inform all the attendees that we will be sharing, with the kind authorization of our excellent panelists, the presentations so they can peruse and study more carefully. Any questions would be, you would be able to raise it directly to our panelists. There will be also a video uploaded in all our social media, the usual ones, Facebook, YouTube, but also the Chinese ones. And we will make a printed publication of this webinar that we will share in due course. So thank you all. And thank you, Miguel Cancela de Abreu, who was the first one to raise this challenge. And here we are today. Thank you.
Thank you so much, Bruno, for your concluding remark. And with this note, I would like to officially conclude this webinar. And thank you to all of you, to both the organizer, the speaker, and also the audience in participating in this very meaningful webinar. To me, I learned a lot from all the speakers, in particular to understand the legal landscape and the arbitration landscape, in particular reference to the maritime sector in the Portuguese-speaking country. I hope with this webinar, this can help the audience to have a further interest in this subject matter and to explore it further. And with this note, I would like to say goodbye to all of you. Thank you and goodbye.
Thank you.
Thank you.
For this speaker, and to know that actually Brazil is a really heavy user of arbitration. It will be good if there will be more arbitration used around and be centered around in the Portuguese-speaking country. Now, with this note, I would like to introduce the first speaker, Professor António Pinto Monteiro. Professor Antonio holds a PhD degree in procedural law and a post-graduation from the Nova School of Law. He is an associate professor as well as a lawyer and an independent arbitrator. Antonio has written several books and scientific articles, and he is currently the editor of APA's Review of Arbitration. He has been distinguished by several entities: Leaders Nation 2021, Portugal Best Arbitrators, Who's Who Legal Arbitration 2021 and 2022 Future Leader, and Legal 500 Private Practice Arbitration Power List 2023. Professor Antonio will read on the new end of the maritime civil law, go back to the home country, Portugal, and speaking about the topic of maritime arbitration in Portugal. Without further ado, may I hand over the floor to Antonio, please.
Thank you very much. First of all, I would like to express my gratitude for the invitation to be here today. It's a pleasure and an honor to participate in this webinar together with you, Mr. David Fong, as well as Mr. José Gabriel Assis Almeida and Ms. Cátia Fernandes. So considering the title of this webinar, which is Maritime Arbitration in Portuguese-speaking countries and in the Maritime Silk Road, the premise of my presentation will be to assess whether Portugal, particularly Lisbon, can one day aspire to be an important center of maritime arbitration, similar to the ones that we can find in London, in New York, as well as in Singapore and China. Well, this is something that makes sense, considering the pro-arbitration stance that we can clearly find in Portugal, particularly in the last 20 years. Just to mention a few examples of this, I mean, we have many disputes being submitted to arbitration, we have many scholarly writings, we have many conferences, courses, post-graduation degrees on arbitration. We have many arbitration centers, and most importantly, good arbitration centers in several matters such as commercial arbitration, sports arbitration, administrative and tax arbitration, consumer arbitration, and soon, I hope, maritime arbitration, a center created by Concórdia. Another example of the pro-arbitration attitude in Portugal is, of course, the Portuguese arbitration law, which I will mention in a few moments, and which was inspired in the UNCITRAL model law. We also have a very active arbitral community and an association, the Portuguese Arbitration Association, APA, which has contributed significantly for the